So talk about this sort of nutty issue where we've got up and down asset protection with trusts and companies. That's all fine, but what about the assets within our businesses? So business risks and businesses are lumped in together, and at the moment, the slides I've shown you, every time something happens in a business, it blows up the business assets. So how do we deal with that? We deal with that by separating business risk and business assets with what I call a dual structure, which are quite common. So we have a business entity where the risks are, and then we put a barrier by setting up a separate structure which has the business assets, and then the structure actually enables the use of those assets back into the business. And then just for good measure, we also have our off-farm assets, our investment assets, which are non-business related, in a separate entity as well. So if you're serious about asset protection, you're really looking at 3 entities to carry on a business and give yourself the best possible opportunity. The other rule, I'm going to go through a series of rules, is that assets always should be above risks. So in the first slide, we've got a business entity which was set up, and then the business owners cruising along, bought some business assets, then had an opportunity to buy a business premises, and rung up, got it set up, and ended up with the business premises either being owned by an entity that was a subsidiary or a separate unit trust or whatever it might have been, and the units were held by the business trust or something like that. And the problem with that is that if the business risk at the top blows up, one of the assets that's available to meet that obligation is your business assets at the bottom. So you actually achieve nothing by having those 2 structures. So what you do is you always have the assets above the business risk. So when the business risk blows up the thing at the bottom, the assets at the top are safe. It's pretty common sense stuff, I would have thought. Next one is separate business activities into risk levels. If you're in the equipment hire business, harking back to the scaffolding guy, equipment hire is a lot less risky than getting your employees to go and assemble scaffolding against a building that someone's going to fall off when it breaks. So rather than blow up your hire business and everything associated with that and the goodwill associated with that, because something goes wrong on one of your service jobs, create a service entity separate from your more passive or less risky hiring activities, which again is separate from your asset entity where you're holding your scaffolding equipment. Once again, hopefully this is all just common sense, but it's worth just going over it again. The other thing we did, it just came up the other day for a client, is, and they actually were in the scaffolding industry, they had the opportunity to get a big contract with a company that's renowned for being pretty tough to deal with. You get a contract and it's not, give us your view on this contract, this is the contract on which you're supplying these services. But they thought they were very clever doing that, but no one actually asked whether the contracting vehicle that we proposed actually had a lot of substance. So what we've done is we've quarantined the risks of that contract in a particular contracting company just for that particular client, because we know that they can be difficult to deal with and our terms of trade don't protect us. Another thing about joint ventures, if you enter into a joint venture and you use your primary business vehicle, when something inevitably goes wrong, you've got everything at risk. We've got one of these clients at the moment, paving business, and they have been fighting a $2 company for years, and they've spent more than what's at risk, essentially, because they can't get away from the claim made by a business partner. And the business partner, if they win, is got nothing of substance, whereas if they lose, their whole business is at risk. So I always say, if you're going to go into a business venture, set up a separate entity which you own less than 100% of, and then vend in the employees and the equipment and the IP or whatever you need on whatever terms for that joint venture, so that if it goes wrong or it blows up, you're not going to be someone who just can't get away at any price. So some other principles: keep your structures clean and up to date, liquidate defunct companies, and you can, obviously that's sometimes an issue because there's loans and that sort of stuff. If you just keep your structure clean, there's no point in having entities that are just sitting there with potential tail liabilities that you're not aware of. Keep your employees away from your investment and maybe even your business assets if you can. So in your operational entities, have your employees there. Primarily because, not because the employees, you're going to want to sack the employees, more that the liability associated with the employees if something happens to them in the workplace. And set up your companies and trusts with defence in mind, which is what we've sort of talked about. So debt. debt is your friend in the sense of if you owe money to a bank, you can be damn sure that their documents are such that there's going to be no equity left if something goes wrong. So a key asset protection strategy is to swap equity for debt when you have the opportunity, because ultimately it's the net equity in your business that's going to be blown up or at risk if something goes wrong. So borrow through the risk entity and then use the assets outside the risky business entity to provide guarantee support. And I've got a picture on that one, but the benefit of that is that if the bank calls on the guarantee, and they invariably do call on the guarantee because there's no point in enforcing security against a business entity that really you can't realise for much. But when they use the guarantee and you pay them out, you get what's called a right of subrogation. So you step into the shoes of the bank against your own entity and you can take what's left as a secured creditor. That's better than borrowing against your house directly and then you lending into your structure and not having the benefit of the bank with its big feet up front against the other creditors. And to the extent that you are lending into your own entities, document it. It's pretty basic stuff. And the other thing is sometimes, if you're going to introduce equity into a business, introduce it at the top in a holding company and then use that company like a treasury function so that it's lending on a secured basis to your operational entities. So, third-party debt, this is just illustrating those principles that I've talked about. Loans to the business entity, takes security, holding entity provides a guarantee, and second security to the holding entity. And once again, that right of subrogation will mean that when the bank calls on the guarantee, the holding company becomes the bank. Now, the Personal Property Security Act is a really interesting thing, and we've got our expert here, Kat, who does the PPSA stuff. It's interesting because it's done a really crazy thing in relation to security. I think it was drafted by the liquidator, or the Insolvency Practitioners Group. Because if you have an asset and you own the asset, so you have outright ownership, and then you let another party use it, so it's in the premises where you're carrying on the business or someone else's, and you don't comply with the PPSA, then when the liquidator comes along, you lose title to that asset. Even though you own it, that's it, it's gone. So they come in, they lock the doors, done. So that there's a statutory override of legal and beneficial ownership in personal property. The only way you can avoid that is to document the lease and to register it on the register, the PPSA register. And so everybody thought the PPSA was about big companies supplying goods and retention of title and all sort of stuff. But really, every single business person out there who's using a dual structure by having assets in one entity and business risks in another and using those assets into that particular business entity, if they're not complying with the PPSA and the business entity blows up, those assets are lost. As far as dealing with banks, there's not a lot you can do. They're in the business of getting their money back, which is fair enough. But, and I know we've got a couple of bankers here, so they can close their eyes and ears for a little minute. What I suggest to clients to the extent that they can, this is usually the sort of medium and the wealthier clients, is if you separate assets into various pots, then you can put the pot up as far as a pool of assets for security. Whereas if you have all your assets in your family trust, and they're worth $1 million and you need a $100,000 overdraft, the bank will have security over $1 million for a $100,000 overdraft. And you can't go to another bank, so there's no competition there when you want the next 100,000. Whereas if you have 500,000 in one pot and 500,000 in another, and one pot borrows 100,000, 500 is going to be plenty to get that, but you've still got 500 unencumbered. So when you've got surplus assets, take them off the table by separating them. And the only way you can do that is by having in a legally separate entity. But then you need to watch out for the cross-collateralisation clause that says that anything you own or anybody you're married to or any kids and uncles and aunts and grandchildren, it's not that bad, but most loans will say that if you bank with us and you haven't paid us, we can just go and take your bank account. And so if you've got your mortgage over your house with the same bank, you've got your overdraft in your business, then you've effectively given a guarantee, even if it's an unsecured overdraft. So once again, an option to address that issue is to actually bank with different banks, have a business bank and have a personal bank. So maybe it's good news for the bankers in the sense they get a little bit of business versus all or nothing. And that's just a diagram talking about having some assets separate and then maybe buying the unencumbered assets in a separate entity. So I'm going to talk now about restructures. So this is in the context of people being in business. They say, well, actually, I'm not comfortable with my structure. I think it's pretty crappy. How can I make it better? Bearing in mind that I've already said that there's probably going to be a tax cost and it's going to be difficult to make work from an insolvency law perspective. So the trick about a restructure is to move the equity. So we move equity by moving assets to a new entity, because the assets might represent equity. Or if we can't move an asset, we can move equity by making distributions, creating liabilities and creating obligations. The impediments to that, as we've touched on, are stamp duty, CGT, insolvency laws and bankruptcy laws. And the ones I'm going to focus on, I'm not actually going to talk about stamp duty and CGT, and I know in the audience we've got some guys who are pretty good at handling that sort of stuff. But in the context of insolvency and bankruptcy laws, how effective is it if we do something like that? So, an obvious one would be to move the business premises out into, say, a super fund. If it's, a small business person, they might get some CGT concessions and that sort of thing. And then lease it back. So we've actually moved that asset outside of the risk environment. Another one might be that we pay regular dividends from our business entity to our holding company. And if we've got two companies, we don't have any issues there about top-up tax and those sort of things. And then have the holding entity reinvest the debt back into the business entity, so effectively provide the working capital and then take security. So you can see by things like regular distributions, not leaving a whole chunk of accumulated profits in your business entity, you've effectively taken those profits out and put them back in as secured debt. Very basic stuff, what I'm talking about here. But it's the sort of thing that creeps over time and you don't do and you just, it's left, or you might just have a business entity without a holding company. Now you can actually interpose a holding company above an operating company quite easily and then consolidate and pay the dividend up. Another way to take equity off the table in a more sophisticated and a dual structure. So this one here was the single structure. This one here is a dual structure where we're making regular distributions and then the holding entity is reinvesting in the asset entity and then the asset entity is making the assets available to the business entity. Now we've done this a couple of times, including for our scaffolding mates who had an existing pool of assets in a single entity and for a number of reasons, one of them was a banking reason, wanted to move some of that equity into a new asset entity that they were going to have a different relationship with the bank with. So we've talked about the man of straw concept, and this is really if it all goes wrong. So we've sort of touched on structural asset protection and the other various strategies that we've talked about, and I now just want to touch on when things go wrong, and inevitably the director or the business person, whatever, tells you they're a man of straw, so they've got nothing to lose and everything's good. Bankruptcy has long-term consequences. It's going to be a minimum of 3 years on the fence, and if you don't behave yourself, it could be 5 to 8 years. And it will impact your ability to be a director and licences and those sort of things. But more importantly for our purposes is that if you do go bankrupt, if the worst happens, then your creditors and your spouse and your trusts and your super are all potentially at risk. So this is the stuff you've taken off the table. So I just want to talk about how at risk those things are, just to give you some perspective on it. So when you become bankrupt by a court order or the acceptance of a petition, and that's the date of bankruptcy, but the commencement of bankruptcy is actually 6 months prior to that legal formal event. And it's up to 6 months if you can find what's called an active bankruptcy in that 6 month period. And active bankruptcy is basically not being able to pay your creditors or doing something, not satisfying a liability, evidencing insolvency effectively. And the first thing your trustee in bankruptcy is going to do is see if they can get any money back off anybody who's received a preference. In other words, even if they've paid full value and everything's fine, they're still going to get it back because you might have paid your mate their bill before paying all the other creditors. So to make sure all the creditors get a fair dip, the trustee in bankruptcy will go back for that 6 month period. And then if you've dealt with yourself, so you've transferred an asset to your trust or to your spouse, so a lot of people will transfer a house to their spouse, for example, then the trustee in bankruptcy can go back 5 years and recoup that asset. So that's 5 years and 6 months effectively from the time that the court or the petition is accepted. But if you can prove that you were solvent when you put the asset into the trust or gave it to your spouse or your children, then they can only go back 4 years, provided you get over the rebuttable presumption that you were insolvent, so you prove your solvency. And not having documents is a presumption of being insolvent, so you can't burn everything. If you didn't deal with your spouse and family relative and trust, etc., if you dealt with, and I actually can't think of actually when you would do that, an undervalued transaction with someone who wasn't related to you, because the definition of related parties is very wide. But let's say you did that anyway. Provided you can show that you were solvent, it's 2 years. But I don't know whether anybody's can come up with an example of where that's most likely to apply. I think you're really in the 4 or 5 year sort of bracket. And then ultimately, if you made a transfer to defeat creditors, so that's different to the undervalue. So here I'm giving you something worth 100,000 for nothing or for $1. This is irrespective of why you've done it, even if it was full market value. If you did it to defeat creditors, there's no time limit. Now obviously the longer something's been in place, the harder it is going to be to show that you did it to defeat creditors, particularly if the creditors didn't exist. But that's actually not enough. But it's certainly, if you've got the ability to prove solvency and the longer time something sits, then I think you're going to have a reasonable opportunity to satisfy the fact that you didn't do it for the main purpose of defeating creditors. So if you push all that together, you're probably talking 4.5 years for an asset protection strategy as a result of a restructure to settle down, to bed down. So I think it's, that's a good context to have as far as thinking about any sort of positive action you take from an asset protection perspective, because that's the reality of it. And then in relation to trusts, they've tweaked things a little bit. So not only did we have Justice French going crazy, at the same time as the barrister, there was, was it Cummins or another chap, Davies or something, hadn't paid tax for 25 years, and everybody was in an uproar. So the government thought it was a great opportunity to make us more responsible, to take away to basically take away the incentive for risk taking, and they introduced Division 4A into the Bankruptcy Act, which says that something along the lines of, if you've made a contribution to a trust and you benefit, so you've transferred a house into a trust and you actually live in the house, or the car owns, you've transferred money or a vehicle in and you use it, then they can put their hand into the trust and pull that asset back out. So that's quite an onerous provision, and then coupled with the concept of control and benefiting, the Rich Star Justice French type scenario, you really are on the back foot a little bit as far as protecting those assets that you put in there. So how do we address those concerns? We structure it appropriately. So this issue of the appointers and the beneficiaries and the trustees, we get all that right. We always pay full market value, which we've discussed. We document solvency at the time we do the transfer. So we actually have the records, not of the transaction, but actually the records that show we were solvent at that time. And a new acquisition of an asset into a vehicle is always going to be better than moving one you've already got. And then, in order to show contribution, so let's say you've moved a house into a trust and it's been there for 4 years, so you're outside the period they can go, 4.5 years, you're outside that period they can go back. But you've been paying the mortgage for 4.5 years. The trustee in bankruptcy can then claim the mortgage because it's a contribution to that asset during that 4.5 year period. So what I suggest to people is that if you're the at-risk person, if you're the businessman who wants to be the man of straw, you pay all the other expenses and have a spouse or some other element of your structure contributing to the maintenance of that asset. And that's what I do. That's my excuse for all the frivolous expenditure that I indulge in. And then use super. So super actually has its own section of the Bankruptcy Act that says that your superannuation entitlements and any lump sum that comes out of those can't be taken by your trustee in bankruptcy. If it comes out as a pension, it's subject to the contribution. So if you earn income as a bankrupt, you need to pay half of that income to the trustee in bankruptcy over a certain threshold, depending on how many dependents you've got. So a pension out of a super fund is included in that income. So you could potentially be paying half of some of those pension payments to your trustee in bankruptcy. Whereas if you get a lump sum, it's all protected. So take things as lump sums, statutory protection. But if you've made a contribution post-2006, then if the main purpose of that contribution was to defeat creditors, so you were insolvent or you were getting towards insolvency and you whacked a whole lot of money into super, then they will be able to claw that back. And there's no time limit on that, so it's similar to that defeat creditor thing under your general bankruptcy provisions. And they determine, in the statute it says they determine whether you've had that main intention to defeat your creditors by looking at the pattern of distribution. So you've been putting 10,000, 20,000 in, each year or whatever, and then suddenly you whack in 350 grand and you go broke. That's the sort of thing that they will unwind. And finally, a practical asset protection strategy is keeping your mouth shut.